I'm going to throw some love to our sponsor, Olson Thielen. Olson Thielen assists legal firms with tax, audit, and advisory services. They invite you to join the weekly online discussion about COVID resources and financial relief. More at otcpas.com. Q&A over coffee, which I believe is on the slider here at the top. They sponsor a weekly webcast themselves, talking about COVID and tax-related matters. Thank you to our sponsor, Olson Thielen. As we've been chatting about, today we're going to listen to our recorded interview with Eric Goldman. I'm going to get that set up now for folks. Landon and I will be available in chat throughout to answer any questions, anything that we can't respond to or is maybe better for Professor Goldman. We will forward on to Professor Goldman. We'll also give, I'll pull up his email he generously shared with us. I'll drop that into chat as well, so you can reach out to Professor Goldman at any time. And with that, let's start our presentation. Not looking forward to hearing my own voice, I have to say, which is always the fun part of having to do one of these things. But here we go with Professor Eric Goldman. Very pleased to be joined by Professor Eric Goldman this afternoon for a conversation about Section 230. We've got the chat room open. You're welcome to type in your questions there, either in the chat or in the Q&A portion. I'm flying solo today without my regular co-host, Landon Ascheman, but I will keep an eye on the chat. I never pronounce your name correctly, Landon, sorry. Looks like we're at capacity. So let's get rolling. I'm very excited to have this conversation now because it feels like this Section 230 is coming under special scrutiny nowadays, and I can't think of anyone I'd rather have chatting about this than Professor Eric Goldman. Why don't we start, Professor, just by telling us a little bit about who you are and your field of expertise.
Yeah, sure. Hi, I'm Eric Goldman. I'm a professor of law at Santa Clara University School of Law. In addition to my normal faculty responsibilities, I co-direct our High Tech Law Institute, and I also supervise our privacy law certificate. My area of research is internet law. I've been working on that field for over 25 years, and I started practicing law in the field of internet law before Section 230 was on the books. So we may get to the old historical perspectives of what life was like before Section 230, and we're still going to talk about how life proceeds with it.
Great, thank you. And I do want to get to the history of Section 230, but before that, before we even talk about why there is a Section 230 and why some have called it, what is it, the 26 words that created the internet, I think I've heard it called. But I want to talk first a little bit about why I'm feeling maybe an urgent need to talk about this issue now. Seems to have been coming under scrutiny. The Department of Justice is calling for regulation. The president, both parties. This is certainly not a partisan issue, I should say. There are certainly partisan elements to it. But what is the urgency? Why is Section 230 right now coming under attack?
Yeah, it's a really good question because you're absolutely right. Section 230 is coming under attack from all fronts, and both of the major parties' presidential candidates have independently said they want to revoke Section 230. That's not a Democrat or Republican issue. And I think there's a couple things going on. One, that there's a lot of fear about the power that's been consolidated in the hands of the internet giants. They are massive companies. They have huge market caps, and they make a lot of money. And there's some jealousy, but there's also some fear about how much power they have over how we interact as a society. And Section 230 is part of that story, but often a misrepresented part of the story. But unquestionably, people think that Section 230 is part of the way in which you might be able to curb the power that's accumulated in the hands of the internet giants. There's also another strand about the people who self-identify as conservatives. I can only use that term in quotes because I don't understand what that word means anymore. But conservatives who feel like their voices are being squelched, that they're not being heard. And among that, they feel like the internet companies are discriminatorily targeting conservative voices for suppression. And they feel like Section 230 is the reason why the internet companies are able to get away with that targeted suppression. So as part of the overall Trumpist era of fighting against certain power institutions, the power that's in the internet giants being allegedly perceived to discriminate against that community creates a really important political narrative. The last thing I'll just mention is that the internet companies, especially Google and Facebook, have made a lot of mistakes over their history. And each mistake undermines the trust that we have in them as an entity. And certainly things like what happened in 2016 elections and the questions about how Russia may have manipulated the elections or engaged in targeted disinformation campaigns contributed to that feeling of trust. Also, the Cambridge Analytica leak where Facebook shared data with a third party who then was able to weaponize that information. Those all made people question what's going on with these companies. How are they able to get away with it? And Section 230 becomes part of that story as well.
And we can talk a little bit about, whether 230 is the appropriate target. But even before that, I wonder if we might talk about a term we haven't heard much about maybe recently, but this idea of internet exceptionalism. And whether or not we're sort of treating internet entities as a special, particular entity divorced from the real world. But I also think that there's, we used to talk about, something like Facebook as, inspiring the Arab Spring. And now we're in a world where we're looking at that, a lot more skeptically because, as you say, of the 2016 election, but also what's happening in the Philippines right now with Duterte and the arrest of journalists and the weaponizing of the internet. How much of this is an unfounded fear of what the internet is, and how much, if it by way of what we might call internet exceptionalism, and how much of it is a genuine concern for either a lack of oversight or regulation, or the failure of the internet companies to regulate themselves?
Yeah, so first I just want to make sure we didn't skip over some of the internet's benefits. You mentioned, for example, Arab Spring as an example where the internet played a potentially powerful role in reshaping governance for good. I would also point out how critical the internet, and especially Section 230, played a role in bridging our society during the shutdowns related to the COVID-19 virus. We basically moved major institutions, our companies, our government, our educational institutions, we moved all of them online in a matter of just days. And it turns out there was an entire internet infrastructure that was ready and available for us to talk to each other in a virtual space. And that ability to talk to each other is in large part due to Section 230. And it's a benefit that I think a lot of us just take for granted. We just assume the internet will always work this way, and it will always allow us to talk to each other in the ways that we want. But actually, Section 2, there's a reason why, and that's why when it's targeted, it becomes such a powerful issue. Now, you mentioned the term internet exceptionalism. Let me just talk a little bit about that. Section 230 says, to summarize, websites aren't liable for third-party content, even if they are legally deemed to be the publishers of that content. Now, that's exceptionalism. If they were legally deemed to be publishers of that content in the offline world, then they would accept whatever default liability attaches to it. Section 230 says they can act as publishers and still avoid liability. That's exceptionalism. And I think that you were asking earlier about why there's been such a growing sense of discomfort with the law. Some of it is a discomfort with that basic liability paradigm. How can they act as publishers and not be liable for it? That's not the way the world has worked in the past. Now, the reason why we might justify internet exceptionalism is because there's some things that we can only do online that never exist in the offline world. And Section 230 is the explanation of that. Things like consumer reviews, or the free access to how-to videos, or the free access to a comprehensive online encyclopedia, or the ability to go to online marketplaces where we can match with independent sellers and buyers in order to transact things that we couldn't find in the offline world. These are all things that Section 230 has enabled only because of the internet exceptionalist rule. Now, last thing I'll just mention in response to your question, one thing that remains constant in both the online and offline world is this general traction towards censorship, that people at their core really are okay with the idea that we should censor what other people can say. And that tendency towards censorship is one of the reasons why the Constitution was so foresighted in enacting the First Amendment that said freedom of speech, where the government cannot restrict what people say. And yet what we're seeing, especially in the internet era, is this almost acquiescence to the idea we should censor how private companies publish content. We should tell them what to do. And to me, that's actually not exceptionalist. That's actually a common thing that we've seen throughout history. The only thing that's exceptional is that people are more willing to entertain that kind of censorial interjection into the online content that they would never tolerate in the offline world.
That's a great summary. Thank you so much. We should probably just take a quick step back and discuss what is the origins of Section 230. What are these 26 words and how did they come about?
Yeah, and I'm sorry, you keep giving a shout out to a book by Professor Jeff Kosseff, Kosseff, from the U.S. Naval Academy. The 26 words that created the internet. It's a great history of Section 230. And it's Kosseff. There he is. And I encourage everyone to check out the book. I learned a lot from it, and this is something I think about all day long. But it's also very accessible to a lay person. Section 230 has its roots in two 1990s cases. The first one in 1991 is a case called Cubby versus CompuServe. And CompuServe is what used to be called an online service or commercial online service. Consumers would pay a subscription in order to access the proprietary servers and content that CompuServe hosted. And CompuServe had a variety of publications available, including the service called Rumorville, which had the ability to upload content that CompuServe then hosted and then that consumers could read on CompuServe. And not surprisingly, Rumorville had defamatory content, or allegedly so, and the plaintiffs sued CompuServe, saying you're publishing this third-party defamatory content. And the court said, well, CompuServe isn't responsible for that content because it didn't even know that it was on there. All it did was allow Rumorville to upload content and it hosted it. It didn't have any reason to know that the content was defamatory. So the court said that it wasn't liable. Now, what we did in response to the CompuServe case is that we generally said, well, maybe we want to not know more about what user content is on our services. If we know about it, we might be liable. But if we don't know, if we try to create this ignorance is bliss approach to managing user content, then we can reduce liability. So that was the dominant advice in the internet law circa 1991 to 1995. In 1995, we got a second case, the Stratton versus Prodigy case. And that case involved a message board on Prodigy where allegedly a user defamed a business. And the business sued Prodigy saying you published this user's content. And Prodigy says, no, we didn't. We just hosted it just like CompuServe. We didn't know about this. And the court held that Prodigy could be liable for having published the user's content because it had advertised itself as a family-friendly service. And it was trying to market itself as creating a curated environment where it was managing the content database. And so because it was curating the environment and advertising stuff as such, the court said, well, if you curate it and you miss something, you're responsible for what you miss. Well, obviously that threw all of us into a loop, because then now if you try and miss, then you're going to be liable for everything you miss. So the CompuServe rule got reinterpreted after the project case to be, don't even try to manage your user content. Don't advertise yourself as actually having a curated environment. The less you do, the less liability you will take. Well, Congress saw that, and they were particularly worked up at the time about online pornography, and they wanted internet companies to do more to crack down on user-submitted online pornography. So as part of a package of laws, they enacted the law, Section 230, with the idea that it was going to eliminate liability for trying and failing, or eliminate liability for creating a family-friendly environment. It was directly designed to overturn Stroud and Oakmont's ruling that said, if you try and fail, you're liable. It was saying, please try. We want you to try. And if you fail, we appreciate that you try. So that's how we got Section 230, is the response to this first ruling that said, don't even look. And the second ruling says, don't even try. And Congress said, please look and please try, and we won't hold you accountable for any mistakes you make.
So it's interesting that the statute was sort of structured this way. I think, and even if it's been successful, there have been some recent attempts to circumvent it. I think is it FOSTA and SESTA, which limited this act. Can you speak a little bit to the efforts that Congress has done to stem sex trafficking, and whether or not that's been successful?
Yeah, so let me just talk a little bit about the history of Section 230 since its passage. So since its passage, Congress basically left it alone for the first 20 plus years. They made a minor change in the mid-2000s that related to banks and gambling. They made another change in about 2010 that doubled down on Section 230 and said that Section 230's rule applied not only to cases that were litigated in the U.S., but if a case was litigated outside the U.S. that would have been preempted by Section 230, the successful plaintiff couldn't bring that judgment back into the U.S. So for the first 20 plus years, Congress basically left Section 230 alone and treated it as if it was working just fine. But starting around the early 2010s, things started really accumulating against Section 230. And one of those strands led to the law that was signed in 2018, FOSTA, that created a package of exceptions to Section 230 that were designed to address the promotion of sex trafficking victims online and the availability of commercial sex advertisements online. And it created exclusions to Section 230 for additional plaintiffs to bring lawsuits, and expanded the scope of potential bases on which someone engaging with that content could be liable for it. That was the first time that Congress really carved back Section 230 in a material way. And of course, everything that's being debated now is how could we further carve it back. So that was kind of the first in what will likely be a series of reductions in Section 230 scope. And
I wonder if we could talk about that a little bit further. I mean, whether or not it's an effective mechanism to stem that kind of activity, maybe comparing it to something like the DMCA, which is its own version of, which is a carve out of this section, isn't it? This idea that with the notice and takedown provision, you've given the provider, the publisher, some notice, and as long as they effectively remove or expeditiously, I guess is the language in the DMCA, as long as they expeditiously remove that content, there should be no liability for the service provider. Why is that not a good, or why is a more open 230 a better system than a notice and takedown provision?
So Section 230 says that websites aren't liable for third-party content, and it has a couple of key statutory exceptions. One is it excludes federal criminal prosecutions, and part of FOSTA was to expand the scope of federal crimes in a way that would create additional liability and would not be covered by Section 230 because Section 230 doesn't cover the federal crimes in the first instance. Another exception to Section 230 is for intellectual property claims, and that would include federal copyright and federal trademark claims. So to fill that particular gap that was created in Section 230 enacted in 1996, in 1998, Congress enacted the DMCA, the Digital Millennium Copyright Act, that included, among other things, the notice and takedown provision that you just mentioned. That if a copyright owner claims that they own a copyright, they can send a notice to the service. The service then can either remove that content quickly and avoid liability, or it can leave the content up and accept whatever default liability might attach to it. And there are a number of good reasons why the Section 230's rule, that flat statement that websites aren't liable for third-party content, leads to differential and improved outcomes over the DMCA's notice and takedown provisions. The notice and takedown provisions have come under some really substantial criticism by civil society, tech companies, and by users themselves, as creating over removals, that it's basically like a heckler's veto, that a copyright owner can send a takedown notice and say, remove it or face liability. The internet companies are going to remove that pretty freely. And so copyright owners can weaponize that. We see, for example, politicians weaponize that all the time. They find ways right before elections to get their opponents' campaign videos removed using copyright as a tool for suppression. And we also see a lot of efforts by people who don't really know the law trying to remove things by claiming that they have a copyright in it. Sometimes successfully, most of the time not. But the point is that by creating that takedown mechanism, it creates a lot of weaponization possibilities that we now see regularly. Now, on the flip side, with respect to Section 230's rule, I think the most important thing to understand is that internet services rarely have the ability to adjudicate truth when it comes to third-party content. And I'll give the example of consumer reviews. The consumer review site has no way of validating if what the consumer is saying is true or not. They lack the information or context to be able to make that assessment. So if a business writes into a consumer review site and says, that review is wrong, and if you want to use the formal words, that review defames me, then under notice and takedown scheme, that review is coming down. Well, what's going to happen in that circumstance? Only the negative content is going to come down. The businesses are going to leave out the positive reviews, but they're going to get rid of all the negative ones. They're going to say with each and every one, that review is not true. You don't have enough context to validate it. So are you really going to accept liability? Most internet servers are going to say, I can't spend the time to research. I don't have the access to information. This particular item of content is not worth the value of investing a lot of labor to corroborate it. And so as a result, we would have a notice and takedown agency would have the ability to basically depopulate large chunks of the internet in very strategic, weaponizable fashion. So Section 230 actually suppresses that weaponization possibility, and we see how it compares then with the weaponization that's taking place in the DMCA realm.
We've also talked, I think, a little bit about, you wrote an article which, in paraphrasing here, said something why the Section 230 is better than the First Amendment. I think there too you talked about how the broadness of Section 230 offers some procedural benefits, offering maybe more motions to dismiss, more success for defendants.
Yeah, actually, Section 230 is an example of what I call a speech-enhancing statute. Legislatures are restricted in how they can suppress speech because of the First Amendment, but they can enhance or enable more speech consistent with the First Amendment if they think that's valuable to do so. And there are some examples of speech enhancing statutes other than Section 230, but Section 230 is a really nice example. It takes principles that are codified in the First Amendment, but then it operationalizes them in a much more elegant, clean fashion for courts and for businesses and litigants to understand what the rule is. So Section 230 both has a substantive footprint. It covers things that would not be guaranteed to get First Amendment protection. But even more importantly, it has these procedural benefits of helping resolve unmeritorious disputes faster. And if the outcome would be the same under the First Amendment or Section 230, but we can get to one faster and cheaper for society with a cleaner rule that's more applicable by everyone in the field, that's actually a win for all of us. It just reduces all of our uncertainty and transaction costs. So Section 230 is better than the First Amendment because it actually covers a lot of the same ground, but it helps us implement its principles in a very efficient manner.
Well, let me ask something on the maybe the business related side of things as well. I mean, oftentimes you'll hear that that the statute will serve competitive companies. Facebook can probably afford a rigorous defense, whereas a young startup company would not. Is Section 230 actually serving, or are we living now in an internet environment where there are so many other barriers, do you think, to entry other than regulation that might prevent a true competitor?
So there's a couple ways to look at this. The internet today looks dramatically different than the internet 15 years ago and maybe even 10 years ago. The power players that we're thinking about today are different than the power players that we would have enumerated in relatively recent history. And so that's a sign that I think the internet ecosystem has remained quite dynamic, and that incumbents do not have guaranteed incumbency, that there's still ways for reshuffling of the deck. Now, I think there are some people who feel like even if that was true 10 years ago, that's no longer true, that Google and Facebook have become so powerful, maybe Amazon has become so powerful, that there really is no way for a new entrant to crack into the ecosystem and dislodge them as incumbents. I don't believe that. I can talk about some empirical stuff, but I'm not sure that it would be persuasive to those who are convinced that this is the end game of the internet, that the incumbents have won and they are permanently the winners. But I will point out that we can see that there's a whole bunch of new power players that have emerged relatively recently, and that we've never had to even talk about in the past. I'm not a fan, but let's say something like TikTok. Now TikTok gets some support from the Chinese government. I understand why you might think that's a little bit unfair, but I'll just say there's a lot of people using TikTok, and I'm guessing many of the people who are watching this video have never used it at all.
In fact, it's funny, we even have members who are now using TikTok for their marketing purposes. I'll make sure to drop that video in on the materials.
Right on. I'm not a TikTok user, it doesn't feel me, but it is a big thing in certain circles where it came out of nowhere in that respect. But I would also point out to things like Zoom. We're having this call over Zoom. Zoom is absolutely 100% dependent upon Section 230 to run its business. And not only is Zoom a new incumbent, but there are dozens, if not hundreds of companies chasing it, trying to outperform it in the video conferencing arena. Section 230 is why Zoom can emerge so quickly and why its competitors are still chasing its heels. So to me, I still see a really dynamic market. I still see the emergence of new power players. And I don't think we've reached the end game of the internet. I don't think this is the permanent configuration that will that is immutable. That's just not. I just don't see any reason why we would think that. Last thing I'll mention about that. Take for example Google's dominance in keyword searches. There's no doubt that everyone who's watching this video primarily uses Google to do keyword searches. But there are other ways to do searches. And so even if Google has dominance in that modality of searching, it may not have the same dominance, say, voice searching as another way in which we can access information we're looking for. And that voice searching might over time become the way in which we prefer to search. When and if something like that happens, Google's incumbency might be restricted to its prior modality, but it doesn't guarantee that it wins in the future modality. The modalities are still evolving, and I don't see any reason to believe that they won't create new opportunities for the existing incumbents to find that they're vastly outgunned in that new modality.
Let me offer some questions from our group. Brent is asking or arguing maybe that 230 may be historically viewed as a speech-enhancing statute, but doesn't the current criticism of big tech's reliance on the statute boil down to use as a hammer to suppress? I'm not sure what the foundation of that argument might be, but rather than enhance open and free speech, if so, wouldn't that defy the original intent of the law? Maybe you're familiar with those arguments.
Yeah, no. I mean, there's, as you point out, there's a bunch of assumptions that's baked into that question, and each of them needs to be pulled out, vetted, questioned whether or not there's empirical evidence to support it, and then debated, and then we can get to the actual question. Okay. But let me just take a couple of.
I should say, Brent, feel free to, and others too, feel free to chime in with in the chat with more detail on that.
But let me just start with, I think, the most important thing, which is Google, Facebook, Twitter are essential players in the way we talk to each other. But they're like just a small fraction of the overall universe of user-generated content. And so there's a lot of conversations that are taking place outside of the Google, Facebook, Twitter triad. And so in that respect, to think about whatever policies they set as dictating the way we talk to each other, I think grossly misapprehends that there's a lot of other stuff going on. And I encourage everyone watching this video to look back at the things that they're using that are not Google and Facebook that are still user-generated content. I think people forget or take for granted how much of the time they spend in that arena. And that really, I think, is an essential part of this discussion. So in that respect, Section 230 is actually doing exactly what we want. It's allowing the breathing room for all those other non-Google, non-Facebook, non-Twitter conversations to take place by companies that don't have the resources of those big players.
The argument for, I have to say, I wasn't even familiar with this concern among conservatives, and again, you know, with the air quotes.
Conservatives.
I agree. It's hard to sort of put a pin in that one, but I would say folks that I would probably identify as conservative scholars have also challenged this with respect to Section 230, that it's stifling conservative voices right now. Is there empirical evidence for that, or what is the source of that concern?
Yeah, so the source of the concern is that that content moderation decisions are zero-sum games. So when a site chooses to leave content up that's challenged or to remove that content, somebody got the outcome they wanted and someone didn't. And so internet companies make millions or even possibly billions of those content moderation decisions every day. And every time someone didn't get the outcome that they wanted, they have the feeling, the source material, the basis to feel like, I didn't get heard, they're not listening to me, and the reason why is because of pick your attribute that someone could be discriminated against. And so, furthermore, because there are billions of those decisions being made every day, you can find hundreds of thousands or millions of people who are in the same, have that same characteristic, all saying, I didn't get the outcome that I wanted. So it's easy to stitch together large communities of people who say, I'm looking to my left, I'm looking to my right, we all have the same allegedly discriminated against characteristic, and we all didn't get the outcome that we want. They must be biased against us. Now, there's a number of pending lawsuits against internet companies alleging that they've engaged in discrimination, and the attributes that they are alleging range all the way from being conservative to being African-American to being gay and lesbian. And at some point you say, if every group feels like they're discriminated against or being biased against, actually, that's proof that there isn't discrimination or bias. It's just the nature of a zero-sum game. Everyone's going to feel drowsy if they didn't get the outcomes that they wanted. In response to this, typically the conservatives then start spewing a long list of anecdotes. But how can you say that X, Y, and Z are all not related, that they aren't all proof collectively of this outcome? And as long as we're talking about it, the anecdotes, I don't care how many you have, because every other group that's suing an internet company right now has at least as many anecdotes. If all you're doing is anecdotes, there's no real rational discussion.
So sometimes we refer to that as anecdata.
I call it garbage data, but okay.
Yeah, yeah, that's right. And I don't know. I mean, first you'd have to quantify or what is subjective content. I suppose. I mean, how do you identify what the content that's been removed even equates to? And then you'd have to have removal data. I don't know if it would even be possible to form a system that would be able to demonstrate bias one way or the other. I mean, is that from a litigation perspective?
Think about how you might do it in the offline world. How would you demonstrate bias in something like, say, the New York Times? Are they biased against conservatives? Are they biased against gay and lesbian people? Are they biased against African Americans? What does bias even mean in that circumstance? Is it based on the number of stories? Is it based on the number of words allocated per story? Is it based on the implicit editorial slant in the stories that actually got published? Is it based on the things that the groups think should have been published that the New York Times chose not to publish? As you can see, we can't even define how we would measure bias because there are multiple dimensions for trying to measure that. And in the end, it assumes that bias is a zero-sum game in that respect, that either you're with me or against me. And it kind of leaves that there's a whole bunch of other areas in between. One other thing that I would point out, there's a lot of people who would say, for example, that internet companies are biased against anti-vaxxers and against anti-vax content. You can call that bias if you want, but my view would be actually that's not bias, that's just science. And so, if you're not going to take up the cause of the anti-vaxxers and say, well, look, here's more evidence that they're biased, it's actually true that they might be differentially removed more than other types of content. And there's a very legitimate reason why we would all want that to be the case.
All right, let me stop ignoring the questions that are coming in here. One in Q&A wants to know, does the impact of Section 230, or how does the impact of Section 230 relate to the demise of FCC's fairness doctrine?
So the fairness doctrine is a rule from broadcasting that said that the broadcasters must carry certain content that they would otherwise editorially choose not to do so. The idea was to produce fair outcomes for two different sides of an issue. But one of the reasons why the fairness doctrine attracted such criticism is because it was telling private publishers, the owners of private property, you must use your private property to carry content that you editorially don't want to carry. So back in the old model of conservatives, and again, we put that word in quotes, but I understood what conservatives stood for back in those days. The fairness doctrine was an incursion on the ownership of private property, and it was the compulsory publication of content that a publisher didn't want to publish, both of which were anathema to the kind of freedom and liberties that conservatives stood for. And so one of the great crowning achievements of the conservative movement in the Reagan era was to eliminate the fairness doctrine, to not force publishers to publish content they don't want, to not be forced to use their private property in ways that they were antithetical to them. So much of what's being debated inside the Beltway today is a resurrection of the fairness doctrine. But instead of it being applicable to broadcasters, the proponents want to apply it to internet companies. This is a bipartisan issue. I can't stress that enough, that the Trump's executive order called for a fairness doctrine. Representative Ro Khanna from the Silicon Valley, represents the district that includes Santa Clara University, came out a few days afterwards saying, we think we need a internet fairness doctrine. So both sides of the aisle inside the Beltway are championing a fairness doctrine for the internet to force private property owners and private publishers to do things that they don't want to do with their publication tools or their property. And the only reason why each side wants that is because they actually favor clipping the freedom of press and speech that the private publishers have. They want to actually impose censorship obligations. So every time I hear a call for internet fairness doctrine, what I hear is we want to impose censorship on private publishers about what content they can and can't carry. And that to me takes it straight into the First Amendment in a way that I find obviously quite objectionable.
So let me ask you the crystal ball question. I mean, part of the reason I wanted to bring this and you to our members was the fact that it is clearly a bipartisan issue. How worried are you that there are going to be inappropriate inroads made to curtailing Section 230?
Section 230 is hanging by a thread. I am hoping that it will survive 2020 and that maybe if the election results give us a new president and Congress, that we'll have a new conversation. I don't know that we'll be better, but I'm hoping to at least be new. But we have to get that far, and I'm not even sure we will. Section 230 is extremely imperiled. And for those of you who love the internet, I hope you understand when I say that, what I'm saying is I think the things that we love the most on the internet are imperiled. They may not survive 2020.
All right, let me return to some of our group questions. Brent clarified, I think he said, certainly Google and Facebook are a small fraction of the social media universe, but the argument is they are incredibly big and powerful factions with vast market power. If the reference platforms are restricting or editorializing speech rather than simply being a conduit for it, Twitter's recent fact-checking of the tweets, I think, and what folks are asking Facebook to do more of. So how do we argue that such editorialization does not defy the speech-enhancing aspect of Section 230?
So, Brent, we would have to have a long conversation over beers, I think, to really get to the root of what you're concerned about, because you use a wide number of different terms in there that each require some unpacking. You're talking about things like editorializing. What do you even mean by that? Or you're talking about market power. Why is that relevant to the publication of speech? There's a bunch of assumptions that are baked into that. Two things I'm going to say in response. One, if there's antitrust concerns that publishers have too much power, then we should view that as an antitrust problem, if we can. Now, I will point out historically that media enterprises have consolidated to obtain market power in almost every medium that has existed in history. And in particular, I'll point your attention to what the conditions were like in the 1970s. Every major metro area had a single newspaper for the entire metro area. And so if that newspaper was biased, had a political axe to grind, there was really no recourse to the target of that bias or axe, because there was only one newspaper in the entire market. And so Florida passed a law to require a right of reply on the part of people who were subject to that in the political sphere. The Supreme Court struck it down, and the Supreme Court said you can't tell newspapers what to publish. That's simply outside the scope of the First Amendment. And the fact that the newspaper had local market power didn't change the answer whatsoever. So even if you think that there's a market power problem, we still don't know that that means that we can tell publishers what content they can or must can't publish. That is not within the scope of the First Amendment, and antitrust isn't really the tool to fix that. Now, the other thing is this idea that if an internet company starts to express an editorial viewpoint, they somehow lose Section 230. That's just not right. Section 230 says websites aren't liable for third-party content. It doesn't matter if they're deemed a publisher or if they have taken some kind of conduit-like approach. That's exactly what Section 230 overturned. If you go back, the model in the Covey versus CompuServe and Stratton versus Project cases were to try to be more conduit-like so that you could avoid liability. Section 230 says you can be a conduit if you want and you're not liable for doing that. But if you want to exercise editorial control over your users' data or your users' content, over your database that you generate from your users, you can do so and you're not liable for whatever choices that you make. So whenever I hear this, you're either an editor or a conduit type argument, or sometimes expressed platform publisher, it really shows that everyone thinks that the law is like it was before Section 230, and that hasn't been the law for 25 years. The law in the last 25 years has been you can be a conduit, you can be an editor, and the legal results are the same.
I think Jennifer Huddleston who wrote a paper. I don't know if you know her. She's kind of cropped up in my prep for this, but she did argue that, and I think she would fall into that conservative camp, just however you define it. Yeah, however you put a pin on it. But she's and I see a question in here. She is part of a I think what you would call a partisan think tank. But she argued that the trend of case law was more towards away from strict liability among publishers towards a more what's the third but away from strict liability anyway. So we've been tending towards a more 230 type of setup anyway.
And I'm familiar with the paper that Jennifer wrote. It was with Brent Skorpa. And I think that the paper is a provocative one. I personally don't agree with it. And my most significant objection to it is that it only analyzed defamation law. And Section 2 applies to thousands of other causes of action beyond defamation law. And it tried to generalize from what it saw, the paper tried to generalize from what it saw as a trend in defamation law and tried to extrapolate it to these thousands of other claims, even though they have different elements and they followed very different jurisprudences. So I don't think that the paper can support the proposition that we would have reached a Section 230-like outcome under the First Amendment. Maybe we would have done that with defamation, but because Section 230 covers so much other stuff, it actually, that the evidence doesn't support the claim. And because I mentioned that Section 230 has all these procedural benefits, those are not dictated by the First Amendment. So even if we got the same substantive outcome under defamation law and First Amendment, we still get procedural benefits in Section 230 that are extremely valuable.
Let me take a quick step back. I don't want to ignore Stan in chat. He says, hold on a second. Doesn't the fairness doctrine only apply to broadcasters that are regulated by the FCC? Citing Miami Herald versus Tornillo, said that newspapers cannot be required.
So that's correct. The fairness doctrine only applied to broadcasters. And the only reason why it could apply to broadcasters is because broadcasters receive a lower level of First Amendment protection than some other media. Things like traditional print publishers don't have the same qualification. And so you couldn't have taken a fairness doctrine for newspapers. That would have violated the First Amendment. But the fairness doctrine didn't violate the First Amendment in a very controversial set of decisions because of the nature of broadcasting. So the Miami Herald versus Tornillo case is the case involving the Florida right of reply statute that I mentioned, where the Supreme Court said that you can't force newspapers to publish content that they don't want to publish, even if they are dominant market players in their local market. So I think the Miami Herald versus Tornillo case is good law today. I think it gives us a preview of how any attempts to oppose fairness doctrines on the internet would go. And yet this concept of imposing fairness doctrines is got a lot of currency in DC from both sides because they're really looking for tools to advance censorship. So when it comes up, if we ever get that far, I expect those laws to be challenged in court, and I don't think they're going to fare well in court. But that's not going to stop the regulators. I don't think they care.
I want to make a pitch for questions before we wrap up here. Feel free to please do throw these into chat. This is a recorded session, and we will be rebroadcasting it in next week, Wednesday morning during our regular scheduled time. But if you've got a question and you want to get it straight from Professor Goldman, please put it in here now. I'm going to address the item in the Q&A, and I'm very happy to sort of, because there's a lot of sort of assumptions, I think, baked into what's going on in the internet. This concept on the first part of this question, I guess I'm not familiar with as an idea, but referring to recent partnerships between big tech and partisan think tanks to censor content. So I'm not. I mean, first of all, what is the what are we talking about there? What is a partisan think tank in connection with with big tech? Is that something that's happening in the industry?
So I see the question here, and I don't understand some of the foundational evidence that it's referring to. But let me just make sure that I was clear on this point. That internet companies could choose to try to do things like fact checking, and Section 230 protects them for doing that. They could choose not to do fact checking, and Section 230 protects them for doing that. So if they think they have the competence to do it, if they think they can do it right, Section 230 gives them that freedom to do so, even if they get it wrong. That was the whole point in the beginning. But if they can't do it and they say, we're not even going to try, Section 230 says, that's okay, we understand that you don't have the ability to get to the right answer.
Specific question about Attorney General Barr's comments about the bait and switch aspect of big tech's approach to gathering users under the auspice of free and open forum, then using their power to editorialize and restrict speech. I do have just a basic question about what it is that the Department of Justice in particular is after here as well, but also addressing maybe Brent's concerns about General Barr's comments.
So I've had a chance to read only some of the DOJ's report that came out yesterday. Yesterday was a crazy, crazy day in Section 230 land. And I'm guessing by the time that people watch this video, there'll have been some other developments that will have also been crazy. It's just where we are today. The DOJ's put out a report yesterday, where this was on Wednesday the 17th, that it basically gave a long list of suggested reforms to Section 230. And the entire report is a little head-scratching if you understand the basic structure of Section 230. Section 230, since the beginning, by its terms, has said that federal criminal prosecutions are not covered. So if the Department of Justice brings a federal criminal prosecution, it doesn't encounter Section 230 in the first instance. So the DOJ is the only entity in the world that gets that guaranteed free pass from Section 230. And as a result, it actually has among the least knowledge and expertise about Section 230 because it's the one entity that doesn't have to address it. So having a report come from the DOJ about Section 230 is a little bit confusing. We don't quite understand what expertise they truly have on this subject. The other thing that the report does, the report has a bunch of things about federal criminal issues that don't really make any sense, because every time they're talking about federal criminal issues, Section 230 doesn't apply, and I think they know that. The other thing is they talk about their concerns on bringing antitrust enforcement. That has been a head scratcher among the Section 230 experts I consult with, because we haven't really been able to come up with an example where antitrust has been limited by Section 230. So to the extent that DOJ is concerned about bringing antitrust enforcements and running to the Section 230 roadblock, I'm sympathetic to that concern. I think it's probably hypothetical. And so it's one of the things where they say there's a scary prospect out there about Section 230 limiting our ability to do stuff. And so we need to fix Section 230. But if it's in fact hypothetical, I'm not quite sure why they would be raising it unless they have other agendas. So the whole report is kind of a head scratcher about exactly why the DOJ is making the moves that it's making and what their real agenda is.
Well, we will stay tuned, Professor. How do folks get in contact with you if they want to follow up with questions of any kind?
So feel free to email me, egoldman@gmail.com. You can follow me on Twitter @Eric Goldman. And if you have the stomach for more rhetoric like I shared with you on this video, you can follow me blog.ericgoldman.org.
Great, thank you. And I will post that those items as well in the Practice Law Library, where we keep some of this stuff in the business as usual library, in the Practice Law Library. Thank you, Professor Goldman. Really, really appreciate you outlining some of these issues for us at this time during this urgent moment. Thank you so much for joining us. I know you are 2 hours earlier than us here in the Central Time Zone, so appreciate you coming in early. All right, folks, that's it. Again, Landon has dropped in the event code 311990. I did post in the contact information for Eric Goldman. I'll repeat it for the folks who, I believe we have a couple of folks attending just by phone. So again, the event code 311990. If you have questions for follow-up, you can send them to Landon or I, or directly to Mr. Goldman. That's egoldman@gmail.com, or on Twitter @Erica Goldman. Or blog, his blog is blog.ericgoldman.org. Thanks everyone for joining us. We're back next week with Thomas Hamilton of Ross Intelligence. We'll be talking about all things AI and legal research and what's going on.
And of course, next week we will be live, but at the same time, we're also changing things up by switching it over to Thursday as opposed to Wednesday.
Thanks, Landon. That's exactly right. Thursdays starting in July. So excellent. Thanks everyone for joining us. I hope you enjoyed our conversation with Eric Goldman. This is one of my favorites. So thanks for joining us. Landon, thank you for hanging out.
Thank you, everybody. And hope to see your names next week.
Take care, everybody. Thanks.